Well, look, Herdig, these amendments, as the Chair has pointed out, all relate to the same basic matter, which is what precisely is to be inserted into the Constitution, consistent with the overall scheme of the proposed amendment. And I want at the outset, if I may, to say that yesterday we had somewhat fraught discussion in which some people said that their own arrangements were under attack by anybody who opposed the making of this amendment, and nothing could be further from the truth. I fully respect the personal lives and arrangements that everybody in this House has made, and nothing I say is intended to cause any offence or hurt to anybody, and I wouldn't do so willingly, and I don't think I'm doing so at all. It seems to me that one of the fundamental, I was interested in what Senator Hoy just said about the O'Mara case, because the argument is made that the O'Mara case strengthens the need for this constitutional amendment. And for my part, I take the exact opposite view. In my view, the O'Mara case, which was decided yesterday, demonstrates the absence of a need for the amendment that we're dealing with. Firstly, we should remember that the majority decision in the O'Mara case upholds the proposition that the family is under the Constitution based on marriage. That's what Mr. Justice O'Donnell's and his colleagues' decision upholds, and it's the majority decision. And that, Mr. Justice O'Donnell says, is the plain meaning of the existing Constitution. And so we start from that point. But even though the Constitution says that the family is based on marriage, and even though the majority in the O'Mara case proceeded on the basis that that was the Constitution and the clear meaning of the Constitution, the Supreme Court nonetheless looked to the situation of the O'Mara family and concluded that the provisions of the social welfare legislation in respect of the widow and widowed persons' pension arrangements were unconstitutional insofar as they infringed Mr. O'Mara and his children's equality rights under the Constitution, holding that their social need, objectively looked at, was indistinguishable from the social need of somebody who would be in his position who had in fact married the children's late mother. And it seems to me on that account that the O'Mara decision shows that two things. Number one, it puts the ball into the government's court now to bring in amending legislation to the Social Welfare Acts to provide for people in the O'Mara situation. And secondly, it states for the first time that the special position of marriage in the Constitution does not warrant an invidious discrimination against persons who are in a domestic situation indistinguishable except for the fact of marriage from people who are married. So, two things. The present wording of the Constitution does not in any shape or form prevent this House from passing the legislation that will be necessary consequent on the Supreme Court's decision. And secondly, the majority in the Supreme Court have explicitly held that the present provisions in the Constitution do not prevent this House from doing justice to the O'Mara family. Now, it seems to me that it's very important to grasp that persons might have said, here's an injustice which is incapable of being remedied because of the special position of the family based on marriage. But the truth is the opposite, that nothing in the Constitution at the moment prevents the Oireachtas from enacting social welfare laws which are just and non-discriminatory to people who are in domestic situations which are differentiated by the fact that there isn't a marriage underlying them. So the argument that that somehow being fair and equitable to the O'Mara family and people in their position depends on changing the Constitution simply doesn't stand up. On the contrary, the majority decision indicates very clearly that notwithstanding that the family for constitutional purposes continues to be based on marriage, it is not merely the right of the legislature to do justice to the O'Mara family, it's their duty. It's their duty, constitutional duty to do so. So, from that point of view, you have to ask yourself, what are the other implications of the O'Mara decision? And one of them, for instance, in my view, is, as mentioned by Senator Hoey, there are knock-on consequences, in my view, and you don't have to have a degree in law or jurisprudence or anything else to see this, for the taxation system. If two people, if somebody in Mr. O'Mara's position can point to a family based on matrimony and say that they are given an income tax regime which is far more favourable to them than his situation, being a single father with dependent children. If he can point to that, any resourceful lawyers on his part will go back to 1980 and look at the Murphy decision and say, if we, well, they first of all look at O'Mara and they'll say, what are the criteria which say that the O'Mara family must have a much heavier burden of taxation than it would have if Mr. O'Mara had been able to marry his partner before her unfortunate death. And it seems to me to follow from that there will inevitably be challenges to the existing tax regime arising from the O'Mara decision. And then, and that's something which we're not discussing in one sense here today, but there will be, it's coming down the litigation tracks, that people will look at O'Mara and say, it's bound to lead to other challenges, not merely in the welfare code, but also in the taxation code. And why should Mr. O'Mara and his children carry a much heavier tax burden than they would have done if he had been in a position to marry and had done so his partner at the time before her death? How can it be justified that he's in a position radically different from a taxpayer in his situation who did marry even after all of the children were born, the mother of the children. So that's the first thing. A challenge is coming to our taxation. Now, if we then change the definition of the family to include other durable relations, parties to those other durable relations will have at least as strong a case as the O'Maras to challenge the constitutionality of what they will allege is unfair and discriminatory tax provisions as applied to them. And therefore, it will become a matter of considerable importance socially and for a whole series of other reasons as to what is or is not a durable relationship for the purposes of the Constitution if this amendment is made. Because as night follows day, parties to such a durable relationship, or parties who think they are in a durable relationship, will challenge the tax code. And changes will have to be made to accommodate them. And that raises the issue which the amendment, which is in my name, seeks to deal with fairly and squarely. Who defines a durable relationship? Is it this House and the Dáil? Do we have the right to say it must at least have lasted 2 years? It must at least have had a conjugal aspect to it, which is the case, for instance, in relation to cohabitation, as recognised in law, that the courts have held that the term intimate, when used in the definition of a cohabiting couple, refers to a sexual relationship with them. Do we decide that, or do we leave it to the courts to decide that in any individual case? There's nothing to stop us. And the 2010 legislation, which deals with cohabitation and civil partnerships, but I'm more concerned now with cohabitation because civil partnerships are effectively historical because of the passage of the marriage equality referendum. But if we concern ourselves with the legislation relating to cohabitation, anybody who looks at that legislation will see that the criteria for recognition are determined by the two houses of the Oireachtas. It's not up to a court to say, oh, look, they're cohabiting, and I'm holding that they're cohabiting. The houses of the Oireachtas have, by the terms of the 2010 Act, told the courts what is, and much more important, what is not, cohabitation for the purposes of that statute. And the Minister has been frank enough in his informal briefings with the leader of my group to indicate that it is a deliberate choice on the part of the government in its phraseology of its proposed amendment to leave the definition of durable relationship to be decided on by the courts. But I ask in that context, why did we not do that in relation to cohabitation rights? If that's a wise move, to give it to the courts who are unelected, and once they decide something, you can't reverse out of it. If the Supreme Court says it means X because it's in the Constitution. if that's to be the means whereby you determine what is or is not a durable relationship, why did we bother in relation to cohabitation rights to set out all the criteria as to who is and who is not entitled to be regarded in law as a party to cohabitation? And if you go to the 2010 Act, we say the people who aren't entitled to it, people who are parties to marriages, people who would be excluded by consanguinity rules from having their relationship recognised. All of those things are provided in law. But much more than that is provided in law, because the entitlement of cohabitants in the event of the termination of the relationship to seek from each other assistance, but in the form of financial support and the like, and division of property, is very strictly limited. The mere fact that one has cohabited, unless one satisfies the criteria laid down in that Act, does not entitle one to invoke the provisions of the 2010 Act. So, what my amendment is proposing to do is simply to say that the two things: number one, that an enduring relationship would have to be one which was between two persons, and it could be parent-child, but at least it would have to be between two persons, and it also would have to be as prescribed by law, so that these houses could say, well, 6 months together is not enough, or 3 years together is enough, and much more importantly, that the presence or absence of children, which is one of the criteria under the 2010 Act for recognising cohabitation, is or is not to be a criterion in determining what is a durable relationship. Because if two people move in together for a number of years, and the case law, I don't claim to be a family law expert, but I was reading it today in the Family Law and Context book, which deals with this in great detail. The case law clearly lays down the criteria and the factors that by statute a court is obliged to consider in deciding that people are cohabitants for the purpose of deciding whether they have any remedy against each other in the event of their relationship breaking up. But all of that is going to be swept away by this amendment, because in future, presumably the average cohabitant is going to be deemed to be a party to a durable relationship. And the right of the Oireachtas to say, well, these are the criteria by which a court must judge the matter. The right of the Oireachtas to do that is not recognised in the government's proposed amendment. And that's a serious matter. I mean, for instance, just pose yourself this question. If a durable relationship does not involve having children, necessarily, and I presume from everything that's been said here that it doesn't. If it doesn't, does the fact that there are children in any particular case lend weight to the entitlement of people to have their relationship considered durable? Or is that something which is, the courts are free to define a durable relationship without regard to whether children are or are not present as a result of the relationship? And when I say as a result of the relationship, there are many cases, I'm sure, where effectively step-parents move into a situation where children are not their own natural children, but they are nonetheless something that the court might take into account in determining whether this was to be defined as cohabitation for the purpose of the 2010 Act. Now, the point that I make is this: why should it be, how does it make any sense to take away from the houses of the Oireachtas the right to set out the criteria for recognition? We can do it, and if we get it wrong, we can change it. And if we did so in an impermissible way, the Supreme Court could tell us we'd done it in an impermissible way. But if we actually say that it is entirely a matter for the courts to decide, and not a matter for the Oireachtas to prescribe, then we are in fact robbing ourselves of flexibility in this area. I'll give you two examples which may be of interest to some people. Cohabitants obviously can end their relationship in various ways, but one of them can be where one party to the cohabitation unilaterally decides to end it and to move out. There's a difference between that and separation and divorce, because the marriage that exists in a married situation subsists, and the duties under it subsist, and the obligations and the entitlements all subsist after the one party moves out of the marriage home. And if there is a divorce or a separation under the family law legislation that we have at the moment, it's open to a court, in the interest of the children, or in the interest of the I'm going to use the phrase, it's possibly a bit old-fashioned, the abandoned spouse, or the person left by the other, not spouse, partner. It's open to a court to divide up the assets of both parties to a marriage so as to provide for the partner or the offspring of a marriage. And the Constitution requires that there should be, before any divorce is permissible and before a marriage ends, under the Constitution as it's currently framed, the Constitution provides that a court must ensure that there has been adequate provision for the children of the marriage. So that if somebody wants to go off and for perhaps good reason, remarry a different person, the first thing they have to do, and they won't get the right to remarry, is to ensure that the partner and children of the first marriage, if there are such, have been adequately provided for. That doesn't exist in cohabitation. You can move out of one home and into another. In fact, you can move out of a home and marry having cohabited, and there is no impediment to you forming a marriage and becoming a constitutionally recognized party to a marriage, arising simply from the fact that you previously cohabited with somebody else. So this is serious stuff. If we say that, people can effectively move in and out of relationships, durable relationships, without, and form new ones, without providing for the offspring of their first marriage, which is required by the Constitution to be done. We are in fact saying something very serious and fundamental about family breakdown, its consequences, and the behaviour of parties to unhappy marriages who may wish to find a happy marriage for themselves. A cohabitant is under no inhibition from moving out and marrying another marriageable person and forming a constitutionally recognised partnership with that person as things stand. So, all of those things are important from the point of view of protecting people who are party to relationships, whether you call them durable or fleeting or semi-durable or short-term or whatever. Parties to such a relationship, I mean, if a man and a woman cohabit and there is a child, there is no inhibition on him going and marrying another woman, as there would be if he was originally married to the first mother of his child, where he would have to, as a precondition to marrying again, he would have to establish that he'd properly looked after the parties to his first marriage. And we're getting rid of that, because we're saying that durable relations are to be given the same status as a family based on marriage. And the provisions of the Constitution which refer to divorce and the precondition of looking after the people in the first marriage before you embark on a second constitutionally recognised marriage, those provisions become utterly redundant if you don't get married in the first place. If I don't marry a woman and have 2 children with her in a 3 to 5 year relationship, I am free. I am not bound by the provisions of the Constitution, which say that I can't marry a different woman and start a family which is recognised under the Constitution as a constitutional family. Whereas if I had to divorce in order to form a second constitutionally recognised marriage, I would have to prove to a court that I had made proper provision for the children. So nobody should try and paper this over. This is a fundamental consequence of what we're doing. We are leaving in the Constitution, and it's important that we should just look at it. We are leaving in the Constitution the following. We're saying that the state pledges to guard with special care the institution of marriage and to protect it against attack. That doesn't deal with the situation I'm talking about, because I wasn't party to a marriage. And we're saying we're leaving in the Constitution the second section of that, the second part of that section of the Constitution, which says, a court designated by law may grant a dissolution of marriage where, and this is the important point, but only where it is satisfied that there is no reasonable prospect of reconciliation, and 2, such provision as the court considers proper, having regard to the circumstances, exists or will be made for the spouse, any children of either of them, and any other person prescribed by law. And 3, any further conditions prescribed by law are complied with. That's what we say about marriages. This House has kept control of the circumstances in which a marriage can be terminated. And one of them is if, but only if, you satisfy a court that you have looked after the parties to the first marriage, you can have your marriage dissolved so as to enable you to establish a second constitutionally recognised family. But we're scrapping that for non-marital durable relations. We're saying that the only people to whom this will apply are people who got married in the first place. They are the only people who will have to get divorced, and they are the only people who will have to satisfy a court that they've looked after the parties to the first marriage and their offspring in a manner the court considers satisfied. Party to a durable relationship can walk out the door and marry a man or a woman the next day. Well, 6 months, you have to give notice now, but that's about it. You can marry because you're free to marry. And there's no point in pretending we're not doing this, because people aren't reading this Constitution. They're not, the durable relations will not be covered by the provisions in relation to dissolution of a marriage. Dissolution of a durable relationship will not be provided for in law, and the duties of somebody to tidy up the situation they're leaving and to provide for all the people adequately out of their means will not exist as a matter of as an obstacle to forming a second constitutionally recognised family and becoming a party to it. So we can't kid ourselves as to what we're doing. Perhaps, and I had an uncle who tried to persuade me years ago that there should be no reference at all in the Constitution to marriage. Just leave it to people, and leave it to churches, and leave it to people who wanted to enter into legal deeds or whatever they wanted to do, and take it all out of the Constitution. But we are leaving in the Constitution very serious obstacles to dissolution of a family relationship based on marriage, and saying they won't apply to durable relations. And when it comes, for instance, and thank God I didn't, in the period since I was Minister for Justice, I did one family law case, and I regretted it instantly because it's the toughest law you can do. It's the most harrowing and the most difficult and the most important to the people involved, but it really takes it out of you. I think Senator Martin will agree with me on that. If you can avoid being involved in family law and make a few shillings as a barrister, you're well off. But I admire family lawyers hugely. But family lawyers will tell you that, for instance, and I have seen it, farmers with 300 acres have been told that they must set aside 150 acres for their spouse and the children as a provision for the proper provision of the children. That the property of the family and business shares are frequently divided, shares in businesses are frequently divided between parties to separating or divorcing couples. That doesn't happen now. As I read the family law books, it only happens in cohabitation cases in respect of shared property in which they have resided. But neither party effectively gets their hands on half of the other party's private wealth. But we're going for that. If this happens, people who are not married will, on O'Mara's logic, and on the fact that their relationship has the same status in law as a family based on marriage, they will, I think, be entitled to ask for a share in the other partner's private wealth. And I'm not trying to run scare stories here, but I do know, and I have seen, in the one case I did, a farm being physically divided. So that's what we're dealing with in family law as it exists at the moment, because you have to go to court to get your marriage dissolved, and you have to prove that you've done the needful by your spouse and children before the marriage will be dissolved. And none of that will exist if we go down this road. I don't see what was wrong in the 2010 Act, which provided criteria for recognising cohabitation to be determined by these houses. Who is and who is not to be regarded as a cohabitant. What a court is or is not obliged to take into account. What a court is not obliged to take into account. What a court should not take into account. Why is that not to be provided for by law in the case of a durable relationship, when it is provided already in relation to family law, separations and divorces, where the family is based on marriage? And I find, I have to say, a huge lacuna, a gaping hole in saying that the Oireachtas won't have a function in determining what a durable relationship is, but the courts will ultimately decide that. Because we are effectively handing over an essentially legislative power to the judiciary. You know, is 6 months enough? Is 9 months enough? Or does it depend on the judge's attitude to the two people that he or she sees before them, before they're recognised as a family? And that's without even considering the question of a breakup of a durable relationship. Who is to be recognised, who's not? And these houses provided in a liberal and an imaginative way for cohabitants to be protected, but said, if we're going to do that, we will remain the masters of who is entitled to all of these privileges and rights and duties in respect of each other arising out of cohabitation. But we're not doing that here now. So, the second point that I just want to make arising out of yesterday's discussion. Some people said that the points I'd made, I presume in an Irish Times article because they were speaking before I spoke, were disgusting, in that I was relegating what are obviously family relations in a colloquial sense to a two-tier hierarchy where some of them are given recognition and others are not. All I can say about that is, if we are going to have protection of the family, of the institution of marriage with special care and protection from attack for it, why aren't we doing that for durable relations? Why do we say that marriage as an institution, and sometimes I'm reminded of Woody Allen's phrase, if marriage is an institution, I'm not keen on it. Who wants to live in an institution? But if you call it an institution in the technical sense that it's instituted by law, which is what it actually means, why is it that it needs special care, but durable relations don't? And that it can be dissolved only in limited circumstances, but durable relations can be dissolved by the unilateral act are ended by the unilateral act of one party. I don't understand this. And several of the speakers, Senator Higgins said yesterday, you know, that somehow implicit in this was an analogue of the argument that was used in the marriage equality referendum, that heterosexual people's marriages were somehow devalued by the existence of marriage among homosexual people. I don't see that at all here. I'm not arguing that marriage is devalued. I'm saying that we are creating a two-tier situation where one can only be dissolved by divorce, whereas the other can be dissolved by simply closing the door behind you and walking out the door. That's not two-tier, that's not in any sense offensive. It's the legal reality. You can walk out the door. One is different from the other. And one is part of the constitutional fabric saying that it can't be dissolved except in very limited circumstances, and it cannot be dissolved unless you've looked after the parties to it. But there is a broader social issue too, and I want to put this up to the government. I know that probably all of this is futile, but I'm determined to put it on the record. I mean, someone like me who did advocate for the marriage equality referendum, we were confronted with Francis Fitzgerald, the then minister sponsoring it, saying that marriage was a fundamental institution of the state and it was wrong to deny it. And I agreed with this. To a gay couple or a lesbian couple, especially to those couples who were who wanted to look after each other, who wanted to have a spouse status in relation to each other's affairs, and who wanted to adopt children and to bring them up without any discrimination. And we changed the law, and I was an enthusiastic supporter of doing so, because I believed that to deny gay couples and lesbian couples the entitlement to form families was profoundly unjust in the world we were in. And I should say, lest anybody doubts where I'm coming from, when I was Minister for Justice, Glenn, the Gay and Lesbian Equality Network, came to my department, and I said that I couldn't give them, and this is in 2003, I'd say, I couldn't give them a referendum because it would be defeated and because I didn't think my partners in government would be interested in such a referendum. But I would go along the lines of civil partnership, and the group under former Deputy Anne Colley reported, and that turned into the civil partnership aspect of the 2010 Act. But if there is something, if the arguments about gay couples, that they were being unfairly kept out of marriage means anything, it cannot be that durable relations, which they could always form, were an adequate substitute for them. And they would not have accepted it at the time that that amendment was made, and rightly not. But looking now to what is to be the future if this amendment is passed, I do have to ask the broader social question. Are we, and the figures were quoted here, and they were interesting figures, that 40% of children are born out of wedlock at the moment, and that 20% roughly of families are single-parent families. If you mine down into those figures, I actually think that an awful lot of children born out of wedlock are later the subject of a marriage between their parents. I think that probably happens in a lot of them, because the 40% and the 20% don't seem to correspond as figures. But even if there is a very significant cohabiting community who are not interested in getting married, and for one reason or another, we do have to ask the wider social question: is the state indifferent to whether cohabiting couples with or without children are married or not? Is it a matter of complete indifference to the state? Or does the state actually favour marriage? Does the state believe that marriage is in some sense preferable than mere cohabitation? And I don't see the answer to that question being proffered by anyone. I totally accept the proposition that Senator McGeehan advanced yesterday, that people are free to marry or not to marry, and it's none of my business whether they do or not. Personally, it's none of my business. I follow that. I don't go around tut-tutting. But is the state indifferent to that choice? And should it be indifferent to that choice? Especially if you're saying that you're going to guard with special care the institution of marriage. Why are you bothering to guard with this special care if you don't really care whether people enter into it in the first place? And why do you say to parties to it, you can't dissolve it unless you make adequate provision for children, but if you stay unmarried, those rules don't apply to you? I wonder. And of course things have changed from Holy Catholic Ireland, for which I am not a spokesman and never have been. But we've scrapped the concept of illegitimacy. We've instituted cohabitation. There was a reference yesterday to John Charles McQuaid. I mean, he would be spinning in his grave if he thought that any of these things would have been done so shortly after his departure from the religious stage. But when we have a Supreme Court which says to Mr. O'Mara, your equality rights trump the right of the legislature to provide welfare contingent on there having been a marriage at some stage, we have moved an awful long way from the society which was described here so vividly by some of the speakers yesterday. De Valera is Ireland. We've moved an awful long way from that. But we still have to ask ourselves this fundamental question. Does the state put a value on marriage? And if so, why? Is it the commitment? Is it saying, we recognize that you are entering into a legal commitment which cannot be dissolved except by a court order in the limited circumstances provided for in the Constitution? Are we saying that matters? And is there some value or some social good alleged to exist in the semi-permanence of marriage? The social good that was alleged, for instance, to exist in relation to the marriage equality debate and decision of the Irish people.
Okay.
So I just want to finish. I want to finish by saying that those are the questions that I said yesterday that I believe we have to answer. And the amendment in my name keeps for this House the control of what is a durable relationship. And if we hand it away and lose control of that concept, we effectively hand over to the judiciary a vital part of the legislative power of the Irish state.
Thank you, Senator. Next speaker, Senator